Ready? All right. We up? All right. Well, welcome everybody to tonight's class. We're going to be talking about the standard offer to purchase and contract, the Form 2T. As we go through it page by page, we're going to talk about how you may fill it out, what it means, so that way when you have a client that's ready to make an offer, or if you're on the listing side and you receive an offer, you know kind of what this contract states. Is it filled out properly and completely? And that way, hopefully, to make you a more informed and educated agent to become more successful in the future. As we're going through it, if you here in the class tonight have any questions, just let me know. We'll stop and answer them and go over them. Otherwise, we'll just keep going through. Sounds good? All right. Well, we'll start with, of course, page 1. This is the standard offer to purchase and contract. At the top, it talks about terms and definitions. This contract is between buyer and seller. So that's where you would put in who the buyer is and who the seller is. Then next, it goes into talking about the property. There's 2 check boxes for these next 2 questions. First is, will the property include a manufactured mobile home? Yes or no? Next is, will the property that is being conveyed include an off-site or septic lot, boat slip, garage, parking space, or storage unit? Yes or no? Next, it goes on to the address, the city, the state, the zip, the county, and then it gets into other descriptions of the property to make sure that we are conveying the appropriate property. As far as the legal description, the plat, reference, the subdivision, the parcel ID number, and then also the property's deed, book, and page that correlates with the property. All of that information you can find on the tax record. So it is all there. Just have to know where on the tax records to look for it, but it is there for your reference. Next, we get into the purchase price, the big things, the numbers. What is their offering on the property? First line would be the actual whole purchase price. The next lines are your 2 main deposits. First is your due diligence deposit. How much is it, and how is it being transferred over to the seller? The next is the earnest money deposit. How much would that earnest money deposit be, and how is it being transferred over to the seller? These can be cash, personal check, official bank check, wire transfer, or an electronic transfer. If you're doing an electronic transfer, example like a Venmo or a Zelle, those can be done, but verify with the buyer if they are getting a loan that the lender is okay with those means of transfer. Eventually, all lenders, I feel, will be okay with it, but right now there are some lenders that are not okay with an electronic transfer of those means. So if that is an option, you want to get before you send it. Next would be an additional earnest money deposit. An additional money deposit. Why would we have a number of reasons? A good example of that might be if buyers make upon acceptance date, they'll turn over an earnest money deposit, and then after 1 week, they may be turning over the additional earnest money deposit for some reason that may be adequate financial situation stands. So if that is the case, that's where that would go. The next line is assumption. Is the buyer assuming a loan? If so, how much is the balance of that loan that they are assuming? Next is seller financing. Is the financing a portion of this purchase price? If so, what is the balance that the seller would be financing would go there? Next would be building deposit. Is it a new construction and that there is a building deposit put down? If that's the case, then you want to include the new construction addendum, or maybe go to the offer to purchase for new construction. But if that is there, then that would be put there. Now, once you take all of those columns, subtract them from the purchase price, the last number would be the balance, which would be the amount that would be owed at closing, taking the purchase price, that balance would go there. At closing, or if the contract were to terminate or any other thing happened to the contract, however that money would be distributed, which would be agreed upon with all parties. The next section is the escrow agent. Who is the agent that would be holding that earnest money deposit? That's what goes into that blank line. Is it one of the buyer or seller's real estate firm? Is it a closing attorney? Who would be holding that earnest deposit? That goes in there. Blue box, if there's ever a dispute between buyer and seller over the earnest money deposit, that earnest money has to be held in that escrow account until all parties agree and settle that dispute. If the dispute cannot be resolved, then eventually that money will be turned over to the clerk of court, and the clerk of court will hold it until it is resolved. Effective date, moving on to the effective date. The effective date of this contract is when both buyer and seller have both signed it and buyer and seller have been sent a copy of it. It does not have to be a hard copy, it can be an electronic copy. Hence the mailbox rule that we all learned in pre-licensing. Once that has been emailed or sent over to the other party acknowledging that it has been signed, that is the effective date, and that is when the contract is now complete and enforceable. Due diligence and due diligence fee. Due diligence is the period that the buyer is encouraged to do all of their diligence on purchasing this home. Example, a home inspection, appraisal, anything like that that they want to do. There is a material breach by the seller. If there is not a material breach by the seller, the due diligence fee is not refunded back to the buyer. That fee they will not get back. Now, if you read down and during the due diligence period, the buyer has the right to terminate during that due diligence period, and if they so elect to do that, then they are entitled to get the earnest money back. The earnest money can then be refunded back to them as long as they terminate during that due diligence period. On to the next page, we're talking about the due diligence period. How long is that period? That period will begin on the effective date, and you have two options. It can be a hard date, that due diligence period ends on this date, or if you think this contract may be going back and forth with negotiations, may take a couple days to sign and execute, then you have the second option where you can put due diligence period runs through an X number of days from the accepted date. Now, if you feel like your contract's going to be accepted the day you're writing it or maybe the next day, then you may be able to put in a hard date, like for example, February 1st. If you think this contract may be negotiated or maybe days before you can get accepted, then you may want to put in the due diligence period runs 21 days after acceptance date. That would be an example. All of these you would want to discuss with your buyer, give them the opportunity, explain how much time they may need, depending on what they may need to do during their due diligence period, will depict depending on possibly how long you need that period. Now remember, if you make that due diligence period a lot longer, that can become less appealing to a seller. So there are pros and cons both ways, but again, it is up to the buyer to make an offer of what they feel is appropriate for their due diligence period. Next, we're going to move into settlement and settlement date. Settlement is when all the appropriate documents have been finalized and everybody's ready to close and the transfer of title happens. Settlement date, what date does the buyer want that settlement date to happen? Just like the due diligence period, everything is negotiable. So just because a buyer may want a settlement date on one day, the seller may want it on another day, it can be negotiated. But at what time what date is this scheduled to possibly close? That would be the settlement date. If there is a blue box, if there is a delay in closing, then we'll get into that when we get into paragraph 12 as that blue box states. Moving on next to closing. Closing is the completion of legal processes in which everything has been finalized, everything has been signed off on, and the property title is moved from seller to buyer. All right, next we have the big red box talking about North Carolina State Bar has determined that performance of most acts and services require a closing and a practice of law to be performed by a licensed law attorney, real estate attorney. You will need an attorney to help consummate and close this deal. We as real estate agents cannot do that. We are told we cannot do that. We're not attorneys, so you need to hire the professional services of an attorney to handle the closing. Moving on to letter N in this section, special assessments. A special assessment is a charge against a property by a governing authority, and if there are any, we need to make sure that they are relayed over and information is relayed to the buyer. We will talk more about special assessments when we get into paragraph 6A. Fixtures and exclusions. This bottom of this page moving into the next page talks about fixtures and if there are any fixture exclusions. Fixtures are anything that is built into the house, nailed in, comes with the home, things that are made and fit with that home. All of those items should be conveying with the home unless explicitly wrote out in the next section. We have a bunch of bullet points on page 4 about what are fixtures. Prime examples of those: keys, garage door openers, your doors, your appliances. Now, when it's appliances, does not include refrigerators and washers and dryers. Those are considered personal property of the seller, but any other kitchen appliance that is built in, like the stove, a built-in microwave, dishwasher, those appliances would be conveying. Light fixtures. If there's any things that, if you have, and a great example would be is if you have a bookcase that is built in and nailed into the wall, that would be considered a fixture. Now, a nightstand is not a fixture, that's personal property. But you just want to make sure that the seller understands that unless it is written in here that these items do not convey, they all need to stay with the home when the home is transferred to the buyer. Talking about other fixtures, let's move on to unpairing and deleting data from devices. Ring cameras, cameras on the outside, camera floodlights, all of those are fixtures. Those are supposed to stay with the home. A seller is required to delete all of their information off of it and unpair themselves from those devices. So that way when they sell the home, they can no longer access the cameras to someone else's home. So seller needs to know that by the time that house closes, they need to unpair and delete all of their information off of it. Because they also don't want the new buyer, when they take over the home, to have access to any files they may have saved from cameras that have happened while they owned the home. So you want to make sure that's all relinquished. Items leased or not owned. If there are any items that are leased or not owned that are conveying with the home, that is where we will fill that in right there. What would be an example of that? A great example would be as if the seller has rent-to-own appliances. Sometimes people will go to a rent-to-own place to get their refrigerator, their dishwasher, their microwave, their stove. They'll be a rent-to-own. So at that moment, they may not fully own them. If there still is leased payments or money owed on it, it needs to be notated here, and it needs to be paid off prior to closing unless agreed upon by all parties. The next section, other items that do not convey. This is where a seller would put something that they are taking with them that may be a fixture. If there is a sentimental chandelier in the dining room, a chandelier is supposed to stay with the home. But if the seller wants to take that, they have the right to take that. But if they are going to take it, it needs to be written out in here and make it specific. Whatever brand it may be, Tiffany brand chandelier in the dining room. That way it's known which chandelier that is. You don't want to write just light fixture. That's not specific. We want to make sure it's specific. So that way we know. And make sure that, again, all parties have to agree upon it. Now, a big question talking about this is when the listing is in the MLS may say on the listing that there is a fixture exclusion that is not conveying with the house. Now, if that is on the MLS and is not transferred over to the offer to purchase, then it is going to stay because the offer to purchase is going to trump the listing if there is something in the offer to purchase that is also in the listing. So just make sure if there is an exclusion in the listing, you also have it in the offer to purchase. All right. Number 3 on this one is personal property. Is there any personal property that the seller is going to be leaving or conveying with the home to the buyer? That may be the example of a refrigerator or washer or dryer. or maybe the buyer wants the couch in the living room or a dining room table or something. Is there something like that that they are leaving? If there is, and it is an item of value, you may want to run that item by the buyer's lender if the buyer is getting a loan, because sometimes depending on the item, the lender may throw that back and say, we can't have that in this contract because it looks like they're getting a loan for a house and personal items, and loans are just for the home and the property. So if there are big ticket items on there, then it may not be able to put it in here. You may have to do an additional bill of sale for those items, so that way the contract is lender compliant. All right? Because that's, kind of what it said in the blue box, that any personal property that will be part of this sale should be identified in this paragraph. Buyer is advised to consult with buyer's lender to make sure it is okay. Next, we'll move on to buyer's due diligence process. The buyer's due diligence process. This is when the buyer is encouraged to do all of their due diligence, whether it may be a home inspection, an appraisal, finding out about homeowner's insurance, how much that would be, and assuming it is insurable, survey, anything like that that they may want to know. Is the home in violation of any governmental compliance issues or anything like that? Is there any other information that the buyer needs to know about this house to make sure this is the home that they want to purchase, and they are fully up to date on everything that this home has and is coming with it to make sure they still want to move forward with the process. All of this information is encouraged to be done during the due diligence period. So that way, if the buyer finds out something that is a deal breaker and that they need to terminate this contract, and they can have to do that under that due diligence period, so that way they would still be entitled to their earnest money back. Now, this is also when if you're getting a loan, you want to make sure you get your loan application moving, get your loan going. The process for that can be time consuming. So you may want to talk with your lender, find out how much time does a lender need to finalize the loan to make sure you can correlate that with the amount of due diligence period you are requesting. Same thing with your inspections, your surveys. If you're doing any of that, you want to kind of find out how long those may take, so that way you can make sure your due diligence period correlates with those time frames. And there's the whole list of all those different things that the buyer may be doing during that period. All right. Next, we're moving on to sale, lease of existing property. All right, so per the North Carolina contract, this contract is not contingent on the sale or lease of another property that the buyer may own, unless specified onto the next section. But as of right now, it is not. Repairs, improvements, and negotiations. The property is being sold in its current condition. That is North Carolina contract, that all properties are being sold as is in their current location and their current condition. Seller may not be required to engage in negotiations for repairs and improvements. That doesn't mean you can't do them, but just the seller has no obligation to be involved in any type of negotiations with repairs or improvements. Buyer's obligation to repair damage. Now that basically states that if the buyer or anybody working for the buyer were to damage the property, the buyer would be responsible to repair those damages. The example of that would be is if the home inspector is there and the home inspector breaks something, that would be the buyer's responsibility to make sure that is fixed. Indemnity. The buyer will indemnify and hold the seller harmless of any loss, damage, or injury from the buyer or any of the buyer's contractors or any people that may be with the buyer. So a seller is not responsible if you go to a house and you trip and fall. You're holding the seller harmless. That is not, you can't really go after them and sue them. Now, caveat to that is that does not apply if the seller has negligence and did not warn you of that negligence. Like an example of that would be is if there's a hole in the floor and the seller covered it up with a rug and then you step in the hole and get injured. That can be negligence, therefore the seller could be responsible for that. But if you are just walking around and get hurt or lose something or damage something of your own, that the seller is held harmless for those. Buyer's right to terminate. The buyer has the right to terminate during the due diligence period for any reason or no reason at all. They don't have to have a reason, but they have the right to terminate inside that due diligence period, and if they do, they are entitled to that earnest money back. Now, if they terminate after the due diligence period, they still have the right to do that, but at that point, now the seller can go after damages. Example of those damages would be the earnest money deposit. That can then be relinquished to the seller as those liquidated damages for the buyer terminating after their due diligence period. All right, let's move on to buyer representations. How is the buyer going to purchase the home? First option is cash. Are they purchasing the home with cash? If not, next would be a loan. If they're not getting cash, they're obviously getting some type of financing. You need to disclose that first mortgage. Is it FHA, VA, conventional, USDA, or another type? What type of loan are they getting? Are they getting a second mortgage loan also? If so, what are the means of that second loan? That is all the material facts. So that all has to be disclosed because the seller needs to know, how is the buyer paying for this? Now, just because they're getting a loan, again, North Carolina contract states this contract is not contingent on buyer's financing getting approved unless there is an addendum stating that. If there's not an addendum stating that, this contract is not contingent on the buyer's loan. Talking about the other property, this is where we just talked about, does the buyer have to sell or lease another property prior to closing on this deal? Now, this contract is not contingent on that, but if it is for the buyer to be able to close it, we need to know. Does the buyer have to sell or lease that other property? And if so, is it actively for sale or lease, or is it under contract? What is the status of that other property? When does it close or finalize? That may be something a buyer wants to make sure that gets done in their due diligence period to make sure that they have that taken care of so they now have the funds to close. Performance of buyer's financial obligations. To the best of the buyer's knowledge, there is no other circumstances that would, exist as of this date that the buyer's financial obligations would not be able to be performed. So unless set forth herein, is there any other reason that the buyer's obligations cannot be performed? The buyer is stating that there's not. Moving on to disclosures. We have two disclosures that are always going to accompany this offer. The Residential Property Owners Association disclosure and the mineral, oil, and gas rights. Has the buyer received a signed copy of those from the seller? Yes, no, or is it exempt from these? Now, it may be exempt, the property disclosures, for two known reasons, and those two would either be new construction or foreclosure. If it's one of those two, then it's probably exempt from this. But other than that, has the buyer received a signed copy of this? If they have not received a signed copy of this, then they have the right to receive them after this contract is accepted, and if they receive it, they are supposed to receive it within 3 days. And once they receive it, they have the right to then terminate if they learn something on those disclosures that is not appealing to them and they don't want to move forward. So it is encouraged to try to get those prior to this contract, so that way that is all taken care of. But sometimes if you don't have them, you don't have them. So you just need to notate, has the buyer received a signed copy from the seller, yes or no? All right. Number 6, buyer's obligations, responsibility for special assessments. If there are any special assessments that are approved following closing, the buyer takes those special assessments. Now, we'll talk about the special assessments on the seller side when we get to the seller side. But as far as approved special assessments, if there are none, but they get approved after closing, the buyer's taking responsibility for those. The buyer's also taking responsibility for certain costs. Anything that the buyer has to pay to do their side of this due diligence in this contract? Are there any fees associated with the loan, the appraisal, the title search, title insurance, closing attorney fees in preparation of the closing disclosure, recording of the deed, preparation of any recording instruments, anything like that that pertains to the buyer. The buyer understands that that would be something that they will be responsible for. Authorized to disclose information. Buyer authorizes the buyer's lender, the attorney, and the agent on the deal to disclose information that is needed to close this deal and to make sure this contract goes to closing. Buyer understands that there may need to be information relayed amongst different parties. As long as it pertains to getting this deal closed, buyer authorizes that information to be shared with the appropriate parties. Now we'll get into seller representations. First is ownership. How long has the seller owned the property? Has they owned it for at least 1 year, less than 1 year, or does not yet own the property? That needs to be notated there. You can find that probably in the listing because the listing requires that to be relayed on the listing itself. So you can look on there and find out. So find out which one that is and make sure the appropriate box is checked. Next would be lead-based paint addendum. If this house is built prior to '78, then the lead-based paint addendum will be required to be attached with this offer. If so, you will check that box. If it is not required, the home was built after '78, then you will not check that box because the lead-based paint addendum does no longer apply. Owners associations and dues. This goes under seller representation. The seller will do what they can to provide all of the owners association documents and information and dues to the buyer and the closing attorney and the buyer's lender. They may need counts of the financials of the HOA. They may need the bylaws, the CC&Rs. Are there any parking restrictions and information, any architectural guidelines, anything like that? Seller's going to do their best to provide all of that to the buyer. With that, we have what is the HOA, if there is an HOA. We need the name of the association. What are the dues? How much are the dues and how often are those dues paid? And then who is the association manager or the president? All the information that the seller has for the HOA. We need all that spelled out right here. There's 2 spots for an HOA. Sometimes there may be 2 HOAs. If there is, you need to spell out both of them. What are the 2 HOAs? What are their dues? How often are their dues paid? That way it's all in here. Number D here, fuel tanks and fuel. Is there a fuel tank that is conveying with the property? If so, where is that tank? Is it in use or not in use? And is it owned